I'm Chip Carey from Georgia State University, and we've got a great set of panelists today, the first of two sessions, which is designed not to be some theoretical discussion about the problems of migration, or even especially about the Trump administration's plans for mass deportations and other policies that might affect individuals who might have a well-founded fear of persecution or more likely than not to be tortured according to US law and international law, would have a right to file for asylum. It will come up for sure, and we have a section in the second session in a week, November 21st, 2024, to specifically look at the incoming Trump administration policies. But today is a general overview, and next week will be the nuts and bolts in part two, and that's a longer session. Today we're here for 2 hours, and we're trying to give those with relatively limited experience or no experience in the asylum process and serving as an expert witness in particular in either affirmative proceedings after a credible fear hearing or in defensive proceedings in immigration court if someone does not pass the credible fear test or is otherwise forced to have litigation. We are going to start off with our first speaker, Bobby Wu from King and Spalding Law Firm, on the view from a large law firm sponsoring pro bono works in about 10 minutes. And he will be followed by Lisa Knauer of the University of Massachusetts at Dartmouth, who will give us a focus on a country. We're not going to be discussing all the problems, in her case, Guatemala, or with Rob Smith following her on Mexico, but rather the problems facing those whose country of origin or country of transit, respectively, would be, for example, Guatemala and Mexico, and what independent experts and their lawyers would do for a client from that country, and any changes that have been occurring under the Biden administration or even before for those kinds of people, because some countries qualify for temporary protective status, otherwise known as TPS. Bobby will speak after me on the major development in the last 2 to 3 decades of big law firms sponsoring pro bono work on with real-time professional time of their lawyers. Sometimes it involves large teams, sometimes not, but having the resources where necessary to pay for independent experts. We'll also get a view for pro bono work in the next session in a week, and how legal clinics affiliated with law schools or independent NGOs go about their work, where mostly people are volunteering for free. We have a landscape, though, where the vast majority of those in defensive proceedings get about 5 minutes in front of a judge in a mass hearing, usually without any legal advice, usually not necessarily knowing what they're doing, listening through a translator in most cases, and trying to figure out what they're supposed to say with no advance warning. And the vast majority of those people in certain circuits of the United States are denied any further procedures and are scheduled for deportation, or as the legal term of art is used, for removal from the United States. And the landscape has changed, of course, in the last Trump administration, and continued on the Biden administration. Continuity might be the name of the game, even though this parental child separation policy got so much attention, and that was actually ended by the Trump administration, even before the Biden administration. But the policy of keeping people on the other side of the border, the southwest border in Mexico, and scheduling some kind of hearing into the distant future, was a way of keeping potential applicants for asylum outside of the United States. We can also say that between cyber monitoring or a virtual wall and the physical wall that the Trump administration was not able to complete, and which had been constructed well earlier for 20, 25 years. I don't know the precise date when every section of the southwest border wall was being built, but the rate of interdiction of migrants has not been this catastrophe that has been portrayed in the press and the media. Most people for the last 20 years have been caught, and the rates of interdiction, albeit prior to the Remain in Mexico policy, did not prevent them from crossing the border. But when you're on camera, just like in similar virtual walls that exist in certain boundaries, such as Bangladesh into India, for example, and other places in the world where there's a strong anti-migrant policy that's been implemented, the virtual wall is almost as good as a physical wall. And the physical wall can be surpassed as well for various reasons underneath, or not typically over, because it's tall and there's barbed wire. So we're going to get into the nuts and bolts of some of these problems, but I invite panelists to present for about 10 to 11 minutes of their 15-minute slot, and then we'll invite questions from the audience. And the way the audience, if they want to ask a question of an individual panelist during that 3 to 4 minute final segment of each of the 15-minute presentations that we'll have today, to raise your hand, and our helpers from the International Studies Association will unmute your mic and invite you to ask your question. We're not going to screen the questions. We trust they will be pertinent to whatever the person presenting has spoken to. I will not be censoring people unless someone is giving a speech at length or is not addressing a question pertinent to what has been just stated. Another procedure that I would like to call attention to panelists is that try to stick to your topic. There's obviously, we all know a lot of things about asylum procedures, but we will have a 15-minute discussion section at the end of today's session for you to speak on other issues that you think about, either during your presentation or during others' presentations. And I would say to our other panelists, if you want to make a comment as well, you should raise your hand. You can unmute yourself if you're a presenter, and you can make a quick point or ask a question of the speaker who just has spoken in the previous 10 to 11 minutes. So this is the plan for today. I'm giving the introduction now. Bobby Wu from King and Spalding will come next. Then we'll have Lisa Knauer of the University of Massachusetts speak to problems of Guatemalan clients. Rob Smith of Baruch College CUNY and the Graduate Center will speak about Mexican applicants in Mexico, problems of persecution. And both of those countries will begin to address the subject of Thomas Bormann's concentrated presentation on societal violence, whether we're talking about police violence or organized crime violence, and the legal issues that arise when so increasingly in the standard is to say this is not political, religious, cultural, ethnical, or social group persecution or torture, and that is a disqualifying element for asylum, although there are victories that are won on a case-by-case basis. And some circuits are more sympathetic, such as Northern California, as opposed to my district in the Atlanta circuit, where we have some of the lowest approval rates of asylum in the country. And it's very hard to get something that's considered common law crime or regular crime to be considered a basis for persecution or torture. Then I will speak on a variety of countries. I'm a cross-regional political scientist, so I'm going to compare and contrast problems of Haitians, Congolese, Iranians, Iraqis, Cubans, and Venezuelans, and get thick in the weeds later at about 3:15 or 3:20 p.m. And then we'll have our final 15 minutes of general discussion. We'll plan on stopping at 4 p.m. or shortly thereafter, but if we're burning up the screen with lots of comments, we'll continue a little bit over the planned 2-hour session that we have today. So I do want to say a little bit also before we get started on an overview of what the difference is between these different procedures. We will have a session with Rebecca Galemba at 3:30, focusing on some of the early stage processes where asylum seekers are hardly ever given their day in court, as it were. They have no legal representation. And that's in a defensive proceeding. That's a screening process that's designed, at least in some circuits of the United States, to eliminate almost all of those who are there. I should say that, the reason that we have discrepancies in the circuits is until very recently, the Supreme Court had never ruled on asylum issues practically at all. I think there was one major case prior to 2010, 2005 on issues of asylum. And now we've had a few more, but generally most asylum policy is resolved at the circuit level, and the Supreme Court, for whatever reason, has not had 4 judges to vote that they want to take the case historically, perhaps because they realize it's so divisive, or perhaps they have a philosophy of federalism and they want the different areas of the country to have different policies. And this is not regarded as an equal protection issue because these are generally not US citizens who need to be kept to the same standard across circuits. So some circuits have, depending on who's doing the ratings, a 1 to 4% approval rating of asylum applicants to being granted asylum, for example. And others in Northern California, the rates of approval, depending on who's doing the rating, the criteria are used, have approval rates of approaching 50% or even higher in Northern California, which is said to have the highest approval rate in the country. And I suspect this Supreme Court will establish a national standard at some point soon when the Trump administration policies are inevitably contested in court and the appeals get to the Supreme Court. This activist court is more inclined to take it. They may be activists in upholding a circuit court decision, or they may actually want to rule on it particularly and say asylum is no more federalized. It's going to be a unitary policy for the entire country. And I would expect with the makeup of the court and its recent jurisprudence, it will be you could call it repressive if you're a critic, or you could call it an open-minded approach if you favor the policy. Okay, without further ado, I'm going to also ask each speaker to say a few words about themselves. And so I will invite Bobby Wu to speak now on the view from the large law firm sponsoring pro bono work. Bobby?
All right. Thank you, Chip. I appreciate the invitation to be here. I'm an attorney in Atlanta with King and Spalding. In my regular work, I do product liability, defending pharmaceutical and medical device companies. But I've been fortunate enough to work with Chip on a couple asylum cases. I am by far the least experienced person on this call in asylum cases. But my day-to-day work, what I do almost 100% of my time recently, and in fact, just right up until a few minutes ago when I joined this call, is working with experts, both working with our side's experts, developing opinions, preparing them for deposition and trial, and in this case, going after the other side's experts. And so what I thought I'd do is to spend this time giving general advice to those who have never perhaps served as an expert in any capacity before. Kind of broken up into 2 areas, first talking about the reports and then going to testifying. So in terms of the report, one thing to keep in mind is that in asylum proceedings, we are governed by the federal rules of evidence. And under those federal rules, communications between you guys as the expert and the attorneys who are representing the clients, those are actually privileged in attorney work product, which means that the other side is not supposed to ask things like, what conversations did you have with your attorney? Did you write this report or did the attorney write the report? Those things are off limits with three exceptions. The three things they can ask about is one, what are the facts that were given to you by the attorney? And that can include, you've got a bunch of references in your report. Did you look at those or did the attorney give those to you? Where did you get the medical records from? Where did you get other records from? Second, what assumptions, if any, did the attorneys ask you to make in forming your opinions? And third, any communications regarding payment. So that can go to bias and they can ask, what have you been paid, and ask your invoices, that sort of thing. But with those narrow exceptions, your communications with the lawyers in this case are privileged so long as you keep the communications confidential. And that means don't discuss with other people who are not directly working for you and who are not sort of your agents. Don't talk about what you discuss with the attorneys, because in doing so, you might accidentally waive the privilege. Now, at the end of the day, you as the expert, you've got to own every word in that report. It's got to be something that you believe is absolutely true, because when you're in court, the number one thing that you are going to be judged on is your credibility. And that credibility goes all the way back to the report. So if there's something in the report that you think is going too far, put you out on a limb in terms of your opinions, you want to talk with the attorney and make sure that it is edited to your satisfaction, to where you think, okay, this is an opinion that I can own, that I can embrace. And kind of the last piece of advice that I'll give, and then I'll pause and see if there are any questions, is that you really do need to understand that things are very flexible at these hearings. And we appreciate it if you guys can be flexible with us. As Chip knows, these hearings can be rescheduled on very short notice. Sometimes, just within a day or a couple days of it happening. I once saw Chip. He and I were both at the immigration court. I was there for a different case, and Chip found out that day at the desk that his hearing had been rescheduled. For the case that we had together, we had to kind of play by ear and tell Chip, okay, we're going to send a car to pick you up, but we don't know exactly when. Here's the window during which we think it'll happen. So it's not something that's going to happen by clockwork, and we do appreciate it when you can be flexible so that we can put you in at the best time for our case. One thing that has helped that out is that with COVID, courts have become a lot more amenable to having witnesses, especially experts, appear remotely. You generally have to ask in advance if you want to do that, but we've had plenty of experts who have appeared remotely. Sometimes they are medical experts and they're treating patients, and we don't want to pull them away from their practice for half a day or a full day. And the judge in those cases can allow them to appear remotely. That being said, if you can appear in person, I think it makes a better impression on the judge, and you just have greater impact as a witness. But with that, I will pause and see if there are any questions
Yes,
from the group.
Bobby, I have a question, a couple
Sure.
of questions. First, my first case with Bill Hoffman and your firm was for an ethnic Tajik Shia Afghan. And King and Spalding hired two independent consultants from Human Rights Watch on country conditions, hired another person to go into Afghanistan and take photographs of the village that had been bombed, hired me to provide the expert testimony and write the declaration. And that was sort of the peak multi-dimensional, multi-level effort. And we won the case. And the guy's life was literally saved. He'd lost both of his parents, one to a Russian bomb, Soviet bomb, I should say, and the other, in retaliation with combat with the Taliban. But even by King and Spalding standards, that was like the maximum effort I've ever seen in my life. Most of the time, I get called up a week before the hearing, and they say, "Can you write a declaration tomorrow?" And that's it. And whatever you come up with, great. And we might edit your declaration or not, but we've got to get it in because the deadline's arrived. So you're even still, King and Spalding is a very successful law firm with deep pockets, which I mean that as a compliment. And you sponsor a great amount of work. Could you kind of give us an idea of not anything proprietary, but also just the level of effort of King and Spalding and similar large law firms in Atlanta or others that you know about, and what resources you'll have available maybe to challenge the policies? Are we going to rely just on the ACLU's immigration project to challenge policies in the incoming administration, or is this going to be on a circuit by circuit basis? So you have to volunteer through another organization or have multi-sponsored efforts on the legal side, because the amount of legal research to challenge legal policies is much different than individual case analysis.
Yeah. So I'll say that, and I see there are a couple of the questions in the chat, so I'll come to those right after I address Chip's question. But the idea of doing impact litigation is something that King and Spalding is interested in, and other big firms are as well. That's usually kind of in a different track. To do impact litigation, you have to go back in front of the Business Review Committee and say, here's the policy we'd like to challenge or the lawsuit we'd like to bring. And that's going to get a lot of scrutiny in terms of, is this something that we've got the resources to do? Is this something that kind of aligns with, what our firm does and that sort of thing? That's very different from the asylum cases that everyone here is working on. We pretty much have carte blanche there. We've already been signed off to do asylum cases, and there's not going to be a case-by-case, country-by-country determination of which ones we take and which ones we don't. And in terms of the resources that we devote to it, we usually staff them with at least 3 attorneys. You'll have a junior associate, a more senior associate, and a partner working on it. And that's probably going to be more than you see on the run-of-the-mill cases, but that's just how big firms operate. I saw an earlier question here from, I think, Andrew, asking about what are the exceptions under the rules of evidence, federal rules, where the other side can get beyond the privilege. It's any facts given to you by the attorney. Number 2 is any assumptions that the attorney asked you to make. And then the third is any details having to do with payment. And as for payment, again, we're not in a world where the government generally asks for discovery, but just so you know, when we deal with our experts, we tell them, do not include in your invoice the kind of detail that would waive the privilege or that would give more information than you should. would rather see an invoice that has, 1 hour for conversation with attorney than 1 hour for conversation with attorney about the likelihood of this legal theory succeeding. We don't want that kind of detail in there.
Thank you, Bobby. We're going to have to stop and move
Okay, good.
Lisa to join us to speak on Guatemala. Thank you very, very much for a great session, and have a great rest of your day. Lisa,
All right, thank
would you
you.
introduce yourself?
Sure. Hi, I'm Lisa Mayanauer. I'm the chair of the Sociology and Anthropology Department at the University of Massachusetts, Dartmouth, and I have been working on asylum cases for Central American asylum seekers, but mostly for people from Guatemala. So I made a PowerPoint because I'm kind of in an instructional mode, and I also thought I'm going to give a little bit of background and also some information about how I structure an expert declaration. So I thought it would be easiest for people if it were kind of out there on the screen. And I'm also happy to share this with Chip, and you can email it if you would like, or send it to participants if they want a copy of my notes, my outline. So Guatemala, to give a little bit of background, it's one of the most unequal countries in Latin America. And if you look really at any human development index, take your pick: income, literacy, education, malnutrition, childhood malnutrition, infant and maternal mortality. It's all pretty bad. And if you're ever going to write a declaration, you can go look at the United Nations Development Report, and you can get information that can help bolster the claims that you're going to make. The country has a very large indigenous population. Not going to go into all of the nuances of how we decide whether they're 22 or 23 indigenous ethnic groups, but there are a lot. And even still, a large either plurality or majority of the country, depending on which source you look at, mostly living in impoverished rural areas, and área rural, the rural area, is kind of shorthand for being an indigenous person. The country was ruled by the military for much of its modern history. There was a brief, what was called the Guatemalan Spring in the 1940s and the 1950s, with democratically elected governments that unfortunately that only lasted for a very brief period. There was the coup in 1954, supported in part by the United States and the Central Intelligence Agency, which unseated that one of the democratically elected governments, and then ushered in another era of military rule, and set the stage for the armed internal conflict, or the Guatemalan genocide, from 1960 roughly to 1996, which ended with UN brokered peace accords. This was declared a genocide by the United Nations, over 250,000 people. And again, the figures are kind of in dispute, but there are definitely some pretty credible sources to get figures from about the number of villages destroyed and the number of victims. Over 80% of the victims were indigenous, and most of the deaths were attributed to the Guatemalan military and to civilian patrols. So in the post-war, and some people say that there really isn't a post-war, or put, post-guerra in quotation marks, has been characterized by intense corruption, really from the highest levels of the government, including a former president who was forced out of office in a corruption scandal. Otto Perez Molina, former military officer, retired military general, who was unseated in 2015. But the corruption continued, and including up until the present, there are still many corrupt actors. There's a pretty surprisingly large number of current and former Guatemalan government officials, both elected and appointed officials, who are on the State Department list of corrupt and undemocratic actors. A culture of impunity, which means that a lot of crimes don't ever get prosecuted, or don't get adjudicated, generally, and the figures have fluctuated a little bit, 90% plus, depending on the kind of case. There are still a lot of corrupt actors currently still in government, and so this is really impeding the reform agenda of the current government. A question I've been asked in cases that I've testified in since the 2023 elections and since Arévalo was finally installed in January of 2024, I was like, oh, but there's a Democratic government now. Like, doesn't that change things? And the short answer is not quite so much. The Attorney General of the country and other officials are still on the attack against Arévalo, and he really hasn't been able to implement many of the programs that he might have liked to. Inequality persists, and also there are high indices of violence still in the country. Let's see if I can try to get my next slide. What's going on here? Okay. So just a couple of pointers about working, writing expert declarations. And I hadn't met Bobby or heard him speak before, but it's very important to work with your attorneys. You often have more expertise, you know more about the country than the attorney does. And for some firms that don't do a lot of asylum cases, you know more about asylum court and you know more about immigration court, perhaps, than they do. You may have more experience than they do. Making it very clear from the outset what you can and cannot argue. And don't be afraid to say no to an attorney. No, I can't make that argument. That's not an argument that I can back up. I was asked recently, and it turned out that the attorneys hadn't really done a great job of interviewing the client. So their brief said, that she suffered gender discrimination and couldn't continue her education. Well, it turned out that actually she had more education than 90% of the people in the municipality that she lives in, had completed high school, wanted to go study medicine. And it wasn't that her parents were very supportive of her, but she was afraid to go to Guatemala City. So that's not, I said, I can't make an argument that she was prevented from studying because she was a woman. She decided not to, but she wasn't prevented. And then also being clear about a timeline. When is the draft due? How long will it take you to review the draft? When do you need the final version? These are all things that I think are really important to work out. So this is my 10-cent version of an expert declaration, and I think we all do these slightly differently. This is a format that I've used. So I like starting off with an executive summary in case the judge or DHS don't get farther than that. A paragraph at the top that just states clearly in a few sentences what the main issues are of the case, whether it's around a land dispute, gender-based violence. And I guess I should mention, I've done over 120 declarations, most of them for Guatemalan asylum seekers, over half of them for indigenous Guatemalans, but not all of them, many of them women. And many people have suffered various forms of persecution, from disputes over land to gender-based violence. So again, being very clear with the attorneys about what the argument is that they're going to be making, which of the 5 things that qualify one for asylum you're going to be asked to talk about, and often it's more than one. So you want to, develop an argument that weaves together a couple of different things. So an executive summary, your expert credentials. If you have experience in the country, it's important to mention that, how many times you've been there, how long you've been there, what kinds of things you've done when you were there. I think there's a difference of opinion among those of us who work in this area about whether you mention your prior experience as an expert witness. I know that we were in the CGRS, the Hastings Center. The attorneys there said not to do it. I've always done it, and I've never had a problem with that. And then what did you review to prepare your report? The client's materials, State Department reports, newspapers, your own research notes, whatever it is, I think it's usually important to say what are the materials that you reviewed. Then going into some specific issue areas to give some background about gender-based violence or racial discrimination or homophobia, whatever the issues are that you're going to be weaving together. If it's relevant and if you have the knowledge, sometimes a kind of nuanced description of the specific area. So if it's Huehuetenango saying something about, you know, land disputes in Huehuetenango and the history of land disputes in Huehuetenango, that it's not, you know, just something that happened the other day, but that there is kind of a trajectory there. And that also, I think, goes to bolster your status as an expert if you have done research in that area, if you really know that area in depth. Mentioning something about the armed conflict, if it is relevant, and kind of setting the stage for the particular kind of violence, the particular kind of conflict that you're going to be addressing. Describing how the Guatemalan government is unable, and I would say for the current government, not necessarily unwilling, but unable to protect persons in this condition. Looking at the kind of history of impunity, history of corruption, the inability or the unwillingness of the police to protect women, to protect Indigenous people, a summary of the client's experience, and then why the client would be at risk if returned. And in that part, which is basically the conclusion, you kind of pull in elements from the previous part. So that's really what I have to say. I wanted to make sure that I got this all in a short period of time. I clearly can say more about Guatemala, but I wanted to really give people the outlines of this. And in terms of, we're going to deal with more of this in the next week, which I hope some of you will join us, when we will talk about some of the ethical and other challenges in, you know, how do you write about, say, gender-based violence in Indigenous communities without making out that Indigenous men are somehow more patriarchal or more machista than other men, you know, without kind of reinforcing stereotypes. So we'll get into more of those issues in the next session. So I'm hoping that I'm leaving time for questions here, and I will stop sharing my screen so we can see each other a little bit more.
Hi, Lisa. Would you tell us what your experience has been with defensive proceedings in immigration court when you're challenged, asserting that a particular form of repression is not focused on Indigenous people as such or for political activity as such, but rather is just common law crime? Is Guatemala particularly susceptible to that kind of challenge to your assertions that this meets the criteria for asylum?
I haven't actually been asked that kind of question. So it's not something that directly, you know, is this more, I think the challenges more have been around some, not so much on bias, but, you know, is this specific, you know, how narrowly focused is this? Could you repeat the question again? Because I think I kind of lost it.
Well, I mean, the idea here is that particularly in circuits that are more restrictive, they're looking for reasons to exclude you. So deeming an attack on an Indigenous person would, an advocate for asylum would say that is because of her or his indigeneity. And those ICE attorney would quite often say, no, that was just because they had some kind of common law dispute. The person was robbed, it's a democratic government, and so forth. And you did mention that you get the kind of question after regime change, oh, well, this is a democracy, so anything that's violent is no longer attributable to government antagonism on the grounds of political views, religious views, racial or ethnic identity, etc.
So I think it's important in those kinds of questions to distinguish between local authorities and the national government, because the national government doesn't actually control what happens in a municipality. It doesn't have any control over the police in a particular municipality. So I think making that distinction is important. You know, the president doesn't control what happens, the local police, and the local police have a history. There actually have been numerous attacks still against, say, indigenous land defenders since January 2024. So it's not as though that has stopped. And I think it's pretty easy to find some evidence, some fairly current evidence, sadly, that many of these things are still going on, that the mining companies have not just all, picked up and gone away, that gender-based violence is still an issue. So I think that it's, that again, making that distinction between the government at the upper level, that a change of presidency doesn't actually affect things on the ground. There's not a trickle down. So that's one of the arguments that I've been able to make that has been accepted. I mean, it hasn't been able to be kind of challenged, or the judges have accepted that. Judges have bought that.
Thank you so much, Lisa, for switching your schedule and joining us today. And that's a great segue to Tom Borman, who's our next speaker, who is going to talk about the more general problem of Central American violence with his clients in Guatemala, El Salvador, and other countries of that Isthmus of Panama. Tom, would you introduce yourself?
Sure. Thanks, Chip. My name's Tom Borman. I've been working as an expert witness since 2006. And unlike others on the panel, in fact, unlike most people who serve as experts, I'm not tethered to any institution any longer, which it allows me to work as an independent researcher. I'm constantly in collaboration with other experts in El Salvador, Honduras, Guatemala, conducting research, writing articles, things of this sort. But it also has freed me up to respond to requests for expert assistance in ways that people are tied to organizations can't, simply because there's so many other demands on their time. So during the 18 years now that I've been assisting as an expert, I've testified well over 1,000 times and been involved in many cases where my testimony, for whatever reason, wasn't necessary or even allowed. So just getting in a little bit to the heart and soul of this, we obviously don't have time to do justice to the various manifestations of violence that we see in Central America. So really what I'm referring to is gangs, organized crime, gender-based violence, politically related violence, violence against members of the LGBTQ community, and in Guatemala and Honduras, the indigenous communities. And in Guatemala, we're talking primarily about the Maya, and in Honduras, the Garifuna and the Lenca people. So just a couple of points. Number one, as an expert, when you come in to assist in a case, irrespective of the nature of the particular violence that the person has been subjected to or at risk for, you are going to know so much more as a country and thematic expert than DHS counsel, than the judges, than the asylum officers, and more often than not, the attorneys who are representing the client you're working on behalf of. That's not a criticism of anyone else as a legal professional, but when you look at the expertise that's required to really serve as an expert, you're talking about sometimes decades worth of direct experience in the country in question and the themes at hand. That is not something that someone can accrue as a legal professional by reading reports and documents. So you bring a level of expertise, and part of what you want to be doing with this expertise is, first, because the attorneys you're working with typically don't have a depth of knowledge about the subject matter most relevant to their clients' cases, or the historical, political, social, cultural, economic, gender context of that country. You oftentimes are serving as a consultant to the attorneys and really educating them. You are also in the same position with your declarations and your testimony in the courts, or if the case is at the level of the asylum office, there's no testimony taken. It's a document review process. So your declaration is part of what is being reviewed by the asylum officers as they establish a basis for making a decision, yes or no, in terms of this particular respondent or asylum seeker's petition. What you're essentially doing, this is my perception, is you're putting the facts of a particular case into the proper context. Again, the historical, political, social, cultural, as relevant, the gender context. This is bringing your knowledge to bear in a case where the other legal professionals who are involved simply don't possess that level of expertise and background. Part of that, let's say you've got a gang-related claim. You're first laying out what is the context of the country with respect to gangs. Again, those historical, political, social, cultural, economic, gender, as they relate to the gang issue. You're also looking at looking through the lens of gang culture and mentality in order to both offer an assessment of any past threats or harm that the person has been subjected to, future risk of harm if they're returned, again, viewing through the lens of gang culture and mentality. Also, you're looking at what are the factors that affect the ability and the willingness of the government to first control the phenomenon of gang-related violence, as well as to protect individuals who, if removed, who have deported, would be subjected once again to threats of harm to their well-being. Again, you're bringing you're bringing things to bear that is well beyond the scope of anyone else involved in these proceedings. Ultimately, what I believe we're doing is assisting the respondents' attorneys as well as the government attorneys and the legal decision makers, whether it's a judge or an asylum officer, to figure out if and how the facts of any particular case fit within the framework of asylum law. And because the decision makers and others involved don't have the background to really deeply assess these cases, they're really at a disadvantage in terms of their ability to answer that fundamental question. Does this or does this not fit within the framework of the law? So it doesn't matter if it's a gang case, organized crime, gender, LGBTQ, a minority person, an environmental and human rights defender. That's what we're bringing to bear, is the capacity to assist in making these legal decisions. Of course, in a manner that's objective and offering all of our assessments in a way that is defensible. I personally cite very heavily in my declarations. If it's a complex case, I may have up to 130 citations in a declaration. So it's not just my testimony. It's not just me spouting off about something. If I'm challenged about a position, I can refer to many, many different sources, which themselves are typically regarded as unimpeachable. When looking at the structure of a declaration, like Lisa said, all of us, there's similarities and differences within all of us in the way we structure ours. For me, it's always providing, like Lisa said, what is my background to opine in this matter first, and then I do a summary of the case facts in a section. Say it's a gang case again. Person X's responses with gangs or experiences with gangs in country Y. I then do and that's a high-level overview of the case. You don't want to get into real nitty-gritty specifics because ultimately, for all sorts of reasons, no one involved in these proceedings knows what exactly the asylum seeker or other fact witnesses are going to stay on the stand under direct or cross. So never would you as an expert want to put something in your declaration that could theoretically conflict with what the other witnesses say, because then that raises all sorts of credibility issues, both with the asylum seeker, their witnesses, if there are any, and you as an expert. The second individual section I build in, if I'm doing an individualized declaration, is probable risk to person X if returned to country Y. And that's where I bring together the facts of their case and stream them through the country conditions in whatever country they happen to be from. Again, sticking with the example of a gang-related claim, where you're making predictions of risk to the individual if returned. You're offering your assessment as to why that person would be at risk and why the government would be either unable or unwilling or both to protect them. Again, you're just passing this off in written form and then many cases in testimony to the judge to assist him or her in making a decision. And like Bobby said, you're also going to be subjected to cross-examination where the government attorney generally is going to challenge your assessments and your conclusions. My experience in cross-examination is that more often than not, because the government attorneys themselves do not have the background, the training, the experience to really understand. And again, this isn't being critical. It's just, this isn't their field of expertise. More often than not, in my experiences, the challenges to my assessments and to my conclusions really do not work in favor of the government's argument because, number one, they are offering me an opportunity to deepen and reiterate my testimony on behalf of the asylum seeker. And when I say that, I first want to say that I don't ever get involved in a case unless I believe that the person would be at risk if returned to their country of egregious physical harm and quite often death, and that those risks exist for reasons that, as opposed to generalized violence, those apply to that individual for reasons that are very particular to them. So when the government attorneys start challenging an expert, again, not being critical, but they're really kind of outside their element. And that affords an opportunity for me and other experts who believe, based on our understanding, that this person is going to be at risk of egregious harm, often death, and for reasons that relate to them very particularly. So we are offered an opportunity to deepen and reiterate our testimony, oftentimes under cross. Couple of other things that I think are
You might
important.
explain cross-examination just to clarify.
Yeah, oh, when I say cross, yeah, cross-examination from the government, or like Bobby said, oftentimes questioning from the judge. Two more points that are critical, and every expert has their own opinion about this. Number one, when you're conducting an assessment of the facts of the case, do you rely exclusively on documents that the asylum seekers' attorneys has provided you, declarations from them, their family members, other sources, newspaper articles, whatever the sources may be? Or do you, as the expert, when possible, conduct your own interview with the asylum seeker, always with the attorney or attorneys present? I personally have conducted hundreds and hundreds of these interviews. Never once have I done one without the attorney or someone from the office that's familiar with the case being present. And there's a lot of reasons that I think that would be inappropriate. My experience is that in probably 80 to 90% of those interviews, we draw something out that's critical to the case that has never been brought forth in the past, in part because the attorneys may not know the proper questions. They may not have the confianza, the sense of there's reasons people are conditioned to silence and may choose not to disclose facts of their cases. And so the attorneys themselves are oftentimes unaware of critical elements. They may not see the connective tissue between one part of a person's experience and another. For instance, the attorneys may be familiar with gender-based violence in Guatemala, but lack understanding of the dynamics of gender-based violence within gang culture. So it may never occur to them to ask their client, by chance, is the offender associated with gangs in some way or another? It may never occur to the asylum seeker to mention that their abuser is involved with gangs because they don't realize the importance of it. But as the expert, you come in and you ask these probative questions. So I personally am a big believer in conducting interviews because, like I say, 80 to 90% of the time, they yield information that is not come out before that may be essential to the case. The other question that, and this is where I'm going to close out, is the question of, do you as the expert testify or not? A lot of experts and a lot of attorneys believe, well, it's sufficient to simply provide the expert's declaration or affidavit to the court and that their testimony is not going to be required. Well, sometimes that's true. If you've got a case that falls squarely within the framework of the law, you have a sympathetic judge that has an understanding of the dynamics at play, you have a sympathetic professional government attorney, it may very well be that your testimony isn't going to be necessary. But my experience is more often than not, that's not the scenario at play. These cases can be very complicated with lots of layers. The government attorneys and the judges come in with oftentimes very limited understandings. So you run some risks in not testifying. Number one, you have no idea as the attorney what the government is going to present in their evidence or what arguments they're going to make that you may, as an expert, be called to respond to. You don't necessarily know what the asylum seeker or any other witnesses are going to say on the stand that the attorney didn't even know about, or that catches them by surprise that you may be asked to respond to. You don't know if the judge may have particular questions, sometimes a very particular question, that if you're not there to respond to, the judge is going to go on and make his or her decision, just simply leaving that question unanswered. So discuss with the attorneys the pros and cons of testimony versus no testimony. So if anybody has a question, I'm happy to respond. Otherwise, I'm just
Tom,
going to.
you have a question from Sonia Wolf, who asks, can you please clarify what you mean by content that might conflict with other experts' statements?
Okay. Yeah.
Go ahead.
Yeah, I didn't mean to say conflict with other experts' statements. I meant might conflict with other witnesses' statements, such as the asylum seeker. There's a couple things that come into play with this. First, you're talking about generally a very traumatized population. And we all know enough about trauma to know that for people who are traumatized, when you put them in an extraordinarily stressful, unfamiliar, in the case of the courts, adversarial situation, our brains are not functioning properly. The neurophysiology of our brain is very much hampered in those circumstances. So an attorney can prep with their client for hours and hours and hours, and then all of a sudden on the stand, their client will say something completely disconnected. I've been involved in cases where the respondents have spent months or years working with their attorney, talking about their fear if returned to their country. And then all of a sudden, under cross-examination or direct, they're in this traumatized, panicked state. And somebody asks them, are you afraid to return to your country? No. Completely throws the attorney into a spin. So there's lots of ways that there can be conflicts between, or disconnects or inconsistencies between the expert's opinion and that of the other witnesses. One thing I see, and I'll close with this to your question, Sonia, as experts, we oftentimes know more about the big picture than the respondents themselves. In situations of violence, these are people who know how to navigate shark-infested waters, but they don't necessarily have the sophistication to bring an in-depth sociological, anthropological, political analysis to these scenarios, so that they may offer very simplistic explanations that you as an expert realize do not really fully encompass the broader scenario. So you may bring things into the process that the respondents and other witnesses themselves may not be able to bring forth.
I should clarify that respondent means the asylum applicant. It's a legal term of art that refers to the fact that you're responding to the government order to be removed from the country in a defensive proceeding, as it's called. We have another question from Pashka Bueno Hansen. And I would say before I read the question that we probably shouldn't spend too much time advertising our services for ethical reasons. Lawyers used to have a rule against advertising. Now they're allowed to advertise. But Pashka, if I'm pronouncing your name incorrectly, I apologize. How and where do you publicize your capacity to provide this service of expert testimony? I've received requests several times and would like to do more of this. Tom, do you want to comment on that?
Well, every case I've ever been involved with has just been through word of mouth. I've never done anything to advertise anything of my services. But having said that, I think without putting oneself in a position where you could be perceived by the government as marketing your service for the sake of financial gain. Now, most of us do a lot of cases pro bono and low bono. But that being aside, one of the common arguments of bias is, oh, you've been paid, which then is the insinuation that you've somehow skewed your assessment and testimony because you have a financial stake. So advertising is something you want to be careful about. But having said that, you could do, for instance, reach out to the Center for Gender and Refugee Studies. They have an expert witness database. It's totally appropriate for you to register and to present yourself through your CV and a breakdown of your experience, and just simply enter your name into their database so that when attorneys are in search of an expert and they go to the Center for Gender and Refugees expert witness database, there they find you. You list your countries of expertise, your thematic areas, and so that's one way. You could also reach out to groups like Amnesty International, Human Rights Watch, Human Rights First, because they routinely have attorneys contact them requesting expert witness services. One thing that they also do that we have to be careful of as an expert is if you're an asylum seeker in proceedings, you may reach out directly to Amnesty International, for instance, and say, oh, my brother-in-law had an expert witness and it helped him in his case. I want one. How do I find him? We as experts can't really get involved in cases unless there's an attorney, or at least that's been my practice over the years. But nonetheless, reaching out to Amnesty, Human Rights Watch, Human Rights First, Center for Gender and Refugee Studies, and just drop your name and credentials in with them, and then they will refer you, or other people will contact you through those means.
I should add that I think it's important not to come across as an advocate, that you are a neutral expert. And that's what I consider myself to be. I had one experience where I was disqualified, and I'm going to be talking about qualifications to testify in court next week in our part 2 of this series. But, you are an independent social scientist analyst. I don't solicit invitations to work. And again, like Tom, I have word of mouth is usually how people discover me. I am listed in that same database and 1 or 2 others where I just list my name and contact information. But if you come across as an advocate, you'll be hurting the client in this process, and you may be disqualified. And then your only alternative is to claim you're not a country expert, which is for most situations the best way to be qualified, because that's kind of like the broadest category for freedom to answer questions. But if you do get disqualified completely, then you're out of the picture. Or if you get disqualified, you may only be allowed to speak on some sort of general pattern of human rights violations in the world. And that's not likely to persuade a judge who's very focused on the micro impacts on this particular respondent, that is the applicant for asylum, why that person has a well-founded fear of persecution according to one of the 5 categories, or that it's more likely than not that they would be tortured. So I wondered if anyone else has any more questions for Tom. Do you have any more words of wisdom for us?
No, that's the extent of my wisdom.
Okay.
No, and I know Rebecca and Rob are still in the queue, so.
Well, I'm scheduled to go next until 3:30 p.m. and I will go next. And then Rebecca, you'll follow me for 15 minutes to 3:45 p.m. And then we'll have a general discussion among the panelists who are here and the audience if they wish to speak. You can speak by raising your hand, and our ISA representative, Joel, will let you in to speak. Okay, so my presentation for the next 15 minutes or so is going to be more comparative because I am a comparative social scientist, and I've done a lot of work in all the regions of the world just because I was asked to. As I mentioned earlier today, my very first case was for this citizen of Afghanistan who was an ethnic Tajik Shia person. And then by word of mouth, I was asked to do a fair number of Afghan and in the region, Iraqi and Iranian cases. And I have published on all of these countries in a comparative sense, but I hadn't been to any of them, but my testimony was accepted, unlike all the other countries that I have had more experience in, like Cuba and Venezuela and Haiti, as well as Central America, where I was a Fulbright scholar twice in Nicaragua. And I have gone to Haiti almost every year since 1987, initially as an election observer, but also a variety of humanitarian and academic training and exchanges in Haiti, which is the country that I focus most on in my asylum work and in my country-specific scholarship. In the case of Cuba and Venezuela, my going to Cuba was mostly as leading a study abroad program every year from my University of Georgia State to Cuba and got a reputation that way. And in the case of Venezuela, I've been there a few times, but I have a colleague, Jennifer McCoy, who's wrote her dissertation and has specialized on Venezuelan issues for much of her career, although she's gone more broadly into the problem of political polarization recently. What I can say, first of all, is it really depends on what country you're talking about when you discuss country conditions. Although all of Central American countries sound similar, and they do have similar structural violence conditions involving gangs these days, and before armed insurgencies in the 1980s into the early 1990s, before the peace process took place, there are still very distinct regimes. The indigenous element that Lisa mentioned earlier for Guatemala is mostly only true in Nicaragua and the Atlantic coast, where the indigenous population is also mixed with, as in many Central American countries on the Atlantic coast, which is on the Caribbean rim, former Afro descendants, most commonly fleeing persecution from Jamaica and other countries that had slavery in the Caribbean. And then there's lots of mixing, not unlike the Cherokee Indians and African American slaves in the United States in that variety of issues. And on the Atlantic coast of the United States, we have one set of indigenous groups that are actually Afro descendants to some extent, let's say in South Carolina and North Carolina, and then a different indigenous mix with Afro descendants and Afro slaves in the Atlantic coast of Georgia. And I imagine the same is true in the northern Atlantic coast of Florida. Second problem we have, in the case of Cuba and Venezuela, we have the curious phenomenon of Cubans who had the one wet foot, dry foot policy that was the law of the United States, of virtually automatic qualification for asylum in the United States if you were fleeing the communist regime. Well, that's no longer been true for 7 or 8 years. I don't remember the precise date on the top of my head where that policy was ended. I think under the Obama administration as part of the normalization of, or in the direction of normalization of relations with Cuba. And then that was reversed under the first Trump administration, to the point now where both Cubans and Venezuelans who remain in US foreign policy, and I suspect will be, if anything, more considered enemy countries of the United States in the second upcoming Trump administration, where they still are restricted from coming into the United States, whether that's reasons of race or reasons of just general hostility to migrants, or at least migrants coming across the southwest border. Cuban and Venezuelans are largely not considered any differently than any other person crossing the southwest border, which is to say, under the Trump administration, perhaps going to continue to have to remain on the other side of the border. And you'd have to come to the United States by water, perhaps, or some other airplane visa to enter into the United States. And it happens that, Cuba and Venezuela, being in the Caribbean, conceivably could get to the United States on the basis of traveling by boat, Cuba being the closest of the major islands, including Puerto Rico and Jamaica, and Hispaniola, which is Haiti and the Dominican Republic, coming by boat to the United States. In the 1980s, when the first wave of migrants from Haiti came during the baby doc, Jean-Claude Duvalier's 29-year family dictatorship that his father, Francois Papa Doc, had instituted, there were waves of boat people that came into the United States. Haitian boat people were considered an effect on Florida presidential electoral politics. Now, Florida is a red state, so that's not an issue. But the larger reason is that the US Coast Guard is permitted under US law, hasn't been challenged and overturned in US federal court, to interdict Haitian boat people en route to the United States, either in international waters or even, let's say, within the Haitian territorial sea. I don't think the US Coast Guard goes into the Cuban territorial sea 10 to 12 miles out from its shore, but in the remaining 90 miles to Key West and further to Florida, the US Coast Guard not only basically interdicts 99% of Haitian carrying boats, but Cuban boats as well. I think in the last 2 years, the Miami Herald has only reported 2 or 3 boats that have landed in Florida from Haiti. It may be a higher number from Cuba, but now Haitians and Cubans, often because they're coming from South America, but also because they realize they can't get through the dragnet of the Coast Guard to arrive in Florida. So they have to come across the southwest border, which means since late in the Trump administration and continuing into most of the 4 years of the Biden administration, they're not allowed to cross. They have 2 options, either to remain in Mexico and wait for an asylum proceeding 1 to 3 years into the future. That's meant to discourage, I suppose, them from remaining there or trying to make a living in Mexico and so forth, or they just go back home. The second would be under temporary protective status, which applies to some countries, but not others. And the Trump administration has, incoming transitional administration, before taking office on January 20th, 2025, has announced they will end TPS for these countries like Venezuela, Cuba, and Haiti. In the case of Haiti, we have a country that has been basically, since certainly the assassination of Jovenel Moïse 2 years ago, July, almost 2.5 years ago, a country in free fall. It is true that the gangs are concentrated in the capital, but most of the major cities, most of the neighborhoods are controlled by gangs. And that means that even more in an extreme way than even in Central America, and Tom, I would invite you to clarify this, but the organized crime gangs are there. If you cross them, you could be in big trouble. But in Haiti, the gangs control the roads, and you can't enter other parts of the country without paying a high fee, a toll, as it were, into the road to go, let's say, from Port-au-Prince westbound to the lower peninsula to some of those provincial cities, or the road heading up north, Route 1, towards Gonaive, Saint-Marc, and other cities further north. Again, the gangs control the road, and you're not going to get in, and you still might not be safe or asked for additional tariffs or tolls by these organized crime gangs. And the number of people who are in the gangs, the estimates vary. They're said to be growing, but the minimum estimate is 30,000 people in the country are in gangs, and I've seen estimates of up to 100,000 members are in gangs. And the recruitment process comes out of extreme poverty in Haiti. It's always been the poorest country in the hemisphere, a mantra that was a little bit unfair to Haiti because in the last 20 years, per capita income doubled from, well, at least for the poorest people in the country, $1 a day now to $2 a day. And of course, trying to live on $2 a day basically means you get maybe 1, possibly 2 meals a day to eat or not. Haitians, are in a variety of ways discriminated against by the authorities and by individuals because they are obviously darker than even Latin Americans and indigenous Indian people from Central and South America coming northbound toward the southwest border. There's occasionally a time where it works to the advantage to be so dark because in Del Rio, Texas, about 3 years ago, there was an enormous number of Haitians camped out on the Mexican side of the border trying to come into Texas because they had been basically kicked out or discouraged or couldn't be employed anymore in countries like Brazil and Argentina. Chile has not been quite so discriminatory against Haitian migrants and Haitian refugees, depending on what term you use for the particular individual or individuals in Chile. But in Argentina and Brazil, they were essentially kicked out. A few people remained in Ecuador and Peru as they went northbound, but most headed towards the United States, where there are much larger Haitian communities, although not on the other side of the southwest border. Basically, the new Biden administration announced that these Haitians would not come in, that they would all be deported either by airplane directly to Port-au-Prince airport or be sent back into Mexico. And there was an iconic photograph of what looked like a Customs and Border Patrolman on horseback. It looked like he was whipping the Haitian, that had echoes of slavery. And the outcry in response to this one photograph, I've never seen anything quite like it, except for the iconic photograph of a Syrian kid who was on the beach trying to get in from Turkey to Greece and ended up drowning. And as a result of that photograph, up to 1 million Syrian refugees and migrants were let in by Angela Merkel, the chancellor, that is the head of government of Germany, to let these Syrian refugees into Germany. And then there was a backlash against that politically, although they're a marvelous success story. And I should say that, by certain measures, depending how you measure this, Haitians are the most successful upwardly mobile group of migrants and refugees in the United States, in that they're coming from $100 to $200 of per capita income per year to driving a cab or whatever they might do in Florida, where Little Haiti is a neighborhood that is, a transit to middle-class life, much like other groups that move on to home ownership outside of the concentration of new arrivals, like the Chinatowns in Manhattan and the newer one in Flushing, Queens, in New York City. at to $25,000 to $40,000 or $50,000 a year in a year or two, by a factor of 100 times more income than what they had in Haiti. I know that's an imperfect measure, but it shows you that this is a group that are model citizens as part of a more general pattern that the crime rate of migrants and refugees, both documented and legal and undocumented immigrants, generally have a much lower crime rate than US citizens have in the United States. When you're dealing with the Democratic Republic of Congo, you have a war in Eastern Congo that has continued for 30 years, that if you're talking about the direct as well, especially the indirect effects of that war, which is basically the same ethnic war that has afflicted the genocides in Burundi that lasted in the 1980s, and then also up through 2015 from 1999, and of course the much more well-known genocide in the spring of 1994 of the ethnic Hutu majority government killing ethnic Tutsi minorities and even some moderate Hutus in Burundi. And so there's been war in Eastern Congo, and it's continued in part because of the involvement of the neighboring countries, but also because of the lootable resources that go into cell phones for the last 20 years. And now the essential material for the more advanced cobalt and other scarce resources that are going to go into electric batteries and electric cars. And so the warlords have a strong economic incentive not to make peace. This was true of the diamond trade in West Africa with Sierra Leone, Ivory Coast, and Liberia. But somehow those wars were able to be ended in the 1990s, often with the effective use of peacekeeping troops from ECOWAS, some of them from Nigeria in their units that suppressed the wars and led to the arrest of some of the leaders of these warlords in Liberia and Sierra Leone. The Democratic Republic in Congo has had a transition to democracy. So some of the problems that we talked about earlier that pertain to the situation in Central America that Lisa mentioned is that we've had a regime change. How do you claim that you have a well-founded fear of persecution? So that's my 15 minutes of discussion from a comparative point of view. Of course, I have much more to say, and we'll have 15 minutes of discussion, but now I would invite Rebecca, if you're here, to present your 15-minute presentation. And would you say a word of introduction about yourself?
Sure. Do you have the slides so I can put those up?
I will try to do that.
If not, I can share my screen if I'm allowed to.
So there you have it.
Yeah. Am I able to actually change them?
You tell me when to change.
All right, I'll just let you know. All right. Well, thanks again for having me. And sorry I wasn't able to hear the rest of it. I was in other meetings. So I'm a professor at the Joseph Corbell School of International Studies, but actually trained as an anthropologist. And I'm also the co-director of the University of Denver Center for Immigration Policy and Research. And I've done some expert witnessing as well. But what I was going to talk about is a project I've been working on for about almost 2 years now, of looking at the earlier parts of the immigration process and what we can learn from that, as well as roles that we can play as scholars, as teachers, in getting involved much earlier in the process, using our skill set for that, also what we can learn for it. And so go to the next slide. Okay, so through this Court Watch project, we've been doing this since May of 2022, largely in Denver. We've observed over 600 master calendar hearings in the non-detained Denver court. These are a really good opportunity, not only for scholars or advocates or law students, but also I do this with my students, and they learn so much about how our immigration system actually dysfunctions just from doing looking at this project. I think is an interesting kind of even just public advocacy project. And what makes it interesting is that most of these hearings are technically open to the public. There's some exceptions, but by and large, they're, as long as you introduce yourself to the judge as an observer and there's room in the courtroom. In fact, they were supposed to let you in. Again, these are very early hearings where basically people are being advised of their rights. They are making sure they receive the notice to appear, an NTA, checking their addresses, their language, offering a continuance to find an attorney to answer the charges, right, and to file an asylum application.
Continuance is a delay. I just want to clarify.
Yes, that's a delay. In some grant, most cases, although that's different on some expedited dockets, which I'll talk about, they will grant those. But what's interesting is these seem really boring. They seem really technical, but you can learn a lot about obstacles to due process and representation that then many people who do expert witnessing may see, right, the repercussions of that later down the line in these cases. And in fact, some of the due process violations are so pervasive and happen with so little oversight and relative impunity that a lot of advocacy projects have emerged to actually document what's happening in master calendar hearings. And so we actually use forms developed by a national nonprofit called Innovation Law Lab. And there they collect teams throughout the country, and many are trained by local attorneys like we are to submit those forms and to be able to download those tools and track the data and inform advocacy. Although unfortunately, due to lack of funding, they actually just shut down the Court Watch program this summer. Unfortunately, but we do still have the forms if anyone is interested in looking at this tool, and they're still interested, obviously, in having the data when hopefully they're able to get the capacity to ramp back up. And, you know, I think as part of what we can do as scholars is not just tracking, right, the violations. Sometimes you miss things. And in fact, what we often find, at least in Denver, is that most of the judges, although there's some exceptions, are largely following, they're complying largely with the law. It's more, we've done a lot of participant observation of what actually, how they're relaying that information, how people are actually understanding what's happening in court, which really helps you understand the gaps of why most people will likely never make it to a final hearing and why it's so difficult to do so without representation. We've also done about 30 interviews with attorneys around the country, and also volunteering at asylum clinics, which I'll talk about, which is a really other great way to use our expertise to, I think, help people often when there's very little else to help them at those stages of the process. And at the bottom is just a screenshot from some of our data, which we actually downloaded ourselves because the tool was never really effective and then it went away. And so we actually have a lot of data now that we have tracked using these forms and what's happening in court. And a lot of our focus, which I'll talk about in a little bit, was on the dedicated docket. You can go to the next one. So again, for those who don't know, master calendar hearings, again, and these are very short initial hearings. They're beginning, right, of the immigration removal process, where they're basically trying to verify very basic information. And in fact, you learn that this is much more convoluted than it actually is, which I'll talk about some of the common problems that we see happening in court. And again, most of the people and most of the dockets that we're observing are all pro se, so they don't have an expert witness, right? They don't have a psych evaluation. They don't have an attorney, right? They don't have really access to anything. Many people are not even really sure when they're supposed to show up to court, versus those who actually have representation often don't need to appear. That's often done, right, in writing. Whereas we've seen people literally walk 6 hours to get to immigration court. And I think that this demands kind of our attention as advocates, as scholars as well, to kind of assist in these processes, or even just keep the transparency, because again, they have a lot less attention than we've often put on these kind of final merits hearings, right, or individual hearings. But the large portion of the cases that are on the court's docket are actually master calendar hearings. So, right, this is just the Denver data from TRAC, where, you know, in those 2 years, the Denver court heard, 4,800 final hearings, but over 100,000 master calendar hearings. And again, they're much more likely to be unrepresented at that stage of the process, where again, there's room to actually help people, inform them of their rights, correct mistakes, hopefully try to link them up with some kind of legal support. Again, these are the early hearings where they're told about the right to find an attorney, But the fact at the same time, well, judges will say, well, they're really expensive, right? Or they don't have a lot of time. Like you kind of hear, some of this language sometimes going on in court, but it's also where they're given a list of potential legal services providers. And, just to give the statistics again about, this being the stage where people often most need some kind of assistance, even if it's just finding the elevator, to be frank, is that 99% of master calendar hearings in Denver in 2024 were unrepresented, versus about half of those who reach to an individual merits hearing, right? So many people never really even get that far in the process. And again, why it really matters to pay attention to these early parts of the process is it really what sets up how immigrants understand the process, engage with courts, receive information, and again, I think, really helps us understand, some of the more right deterrence aspects going on with immigration court. You can go to the next one. Okay, two of the other things. Oh, sorry, there was a question. Hi, Sonia. Yes, they're all the only ones that are open to the public.
Can you read the question?
Oh, yes, sorry about that. So the question was, can you clarify why your team attended only master calendar hearings? Are these the only ones in the asylum process that are open to the public? The answer would be technically yes. And again, there are some places like we've talked to teams in Ohio where the judge doesn't even let them into master calendar hearings, which is not really allowed. In fact, these forms ask the question, were you allowed in the courtroom? And right, and that's can be a potential violation unless there's literally not space for you to be there. For final hearings, you usually need the permission of the respondent. We've tried to, which I'll talk about, the Family Expedited Removal Management Program. We've been trying to see if we can get approval from attorneys to sit on a few of those in court, specifically because those need a lot of transparency because most people didn't even know what firm was, which I'll explain in a few minutes. But largely because you do need the permission of the respondent. We didn't feel we could necessarily go to enough of those to always offset like the potential, right, traumatizing stories, right, that students would hear, what goes on in those courtrooms. What we'd love to be able to do is follow people throughout the entire process, which is something we're thinking of doing, but obviously for the logistics of the way that I'm going to say immigration court dysfunctions. That's actually a very difficult thing to do logistically. But we were also focused on some of these. And again, I think it really shows where many people are failing out of the system, which we're not paying a lot of attention to. And again, where I think there's a real need for help. And so the two things that we were actually looking at most, because these were identified to us by attorneys of having very little research behind them, policies that were enacted really quickly as kind of alternatives to family detention. I don't know, obviously, if that will, obviously many people think that could be resumed. But these were policies that the Biden administration implemented in the wake of family detention, saying that they were going to still provide they were going to clear the backlog and they were going to provide families with access to due process. And attorneys were like, this sounds a whole lot like Obama's rocket docket. This sounds a whole lot like Trump's family unit docket, which we're also trying to funnel people through the asylum process overly quickly. And in fact, like we're finding the same results, but it's the idea of proving that when this dedicated docket, again, it was targeting recently arriving family units, very arbitrary. So like when you turn yourself in at the border, they can decide to put you on the dedicated docket or they can decide to put you on a regular docket. We can't really find any rhyme or reason to this. The goal is for these cases to be completed within 300 days, which makes it almost impossible for families to prepare and for attorneys to want to take these cases. And from what we've heard from attorneys, that it's not even just that the timeline is quick, is that it's inherently unpredictable. So like it might be reset in like 5 days, right? Or it might be reset in 6 months. And we've seen differences in courts where in Denver, like when people ask for a continuance, like they'll go in for their first hearing and saying, your second hearing's next month, your third hearing's a month after that, your final hearing needs to be scheduled by X date. They're largely not continuing those cases versus we hear in like San Francisco or Boston that they tend to be a little bit more amenable to giving more people to find attorneys through this process. And they're disproportionately enrolling families from Latin America. Like there's a lot of issues with this process. And in fact, when they realized they could not do this quickly enough, they implemented another policy called the Family Expedited Removal Management Program, which I think is something we need to pay attention to because I think this is and we've talked about, many people are writing about this. It's like the toolkit, right, that the Biden administration is leaving, the Trump administration, these kinds of things of these expedited removal are going to be ramped up. And this is from Americans for Immigrant Justice. Again, there's very few attorneys who even know about this program. It's also relatively completely arbitrary, largely disproportionately targeting families from Latin America, crossing or being apprehended or turning themselves in at the border. It largely the calculus that attorneys have realized of what may lead someone to be assigned to this process versus just being given a notice to appear to go to immigration court is largely, are you from a country with regular deportation flights, right? The goal is basically they presume families will not be successful. And is the city that you say that you're going to within a certain GPS radius of an office, the ISAP, the intensive surveillance program that you can check in with. And that's really what we're seeing in being relatively completely arbitrary. We've even seen this result in families being separated because sometimes they enter at different times during different ports of entry and might be assigned to one docket versus the other. And again, these cases are supposed to be done within 30 days, which is just ludicrous. And in fact, the best result you can get and why it's actually a complete waste of resources is that even if you pass through this process, the best result is you end up back in immigration court, whether on a regular or a dedicated docket. Whereas in many cases, this is literally resulting in a credible fear interview in the interior, often at USCIS offices who don't understand these claims within a few days of your arrival to a city. If you're declined, and again, this is under oftentimes new higher standards, which I can also talk about, you have about a week before you're set in immigration court for a final review. Judges also don't seem to understand these cases either because judges in immigration court and a non-detained don't tend to see expedited removal cases. These are cases that previously went through detained contexts, and they often don't know how to deal with them. And if they're denied there, they're often removed within 30 days, which makes it really difficult to find people to help in these particular cases. And what we're finding is when people have any sort of help, whether it's even someone to explain what part of your asylum case is important or what qualifies, they're much more likely to pass through these processes. And again, judge and location still really matter because like we've talked to attorneys in San Francisco where the USCIS seems to know what they're doing and judges seem to be at least you have a shot, whereas in other cases, we're hearing many of these cases either denied or utterly befuddled between USCIS and the court and not really understand what to do with them. And of course, these intersect with new asylum rules, such as the circumvention of legal pathways, which makes it much harder for people to get around higher standards of fear. And now, obviously, we even see fewer people enrolled in these programs under securing the border because, in fact, many of them are just being held in CBP custody, which I'm happy to answer some questions about, and not even really being asked if they have they're not being asked if they have a fear of return. They actually have to cry that out. And in fact,
CBP is Customs and Border Patrol.
yeah, and so they're held in Customs and Border Protection. This is what's happening right now under the Biden administration. Families are given 4 hours to find an attorney, regardless if it's a Saturday, which is insane. Over the phone, attorneys aren't allowed to enter these facilities. It's a mess. Children or teenagers are often separated from their parents, and it is not the same standard we had previously, whereas people were asked if they put into expedited removal and asked if they had a fear of return and referred to an asylum officer. In these cases now, and this is since the summer, people literally have to cry out their fear to be given access to a credible fear interview. And in many times from what we're hearing from attorneys is that Customs and Border Protection officers just ignore this completely. And they're saying, well, asylum's over, right? We don't have asylum. And they're just actually not even listening to people. So these things are really, really concerning. And sometimes have a little less room for advocacy, but some of these expedited removal, at least when they're happening in the interior, there is some space for groups, whether it's attorneys, accredited representatives, even experts, right, who just can speak Spanish, right, and understand these systems can help prepare people. Oh, there's a question. Okay, the nuances of firm are interesting. Can you recommend any literature to understand how these function? I would say read, we're working on a report right now. It's taking a little bit of time, but I would say Americans for Immigrant Justice has the best reports out there. They're basically the ones doing this work. If you know attorneys, I would connect them because they can't handle them all. And I think what's so hard about this program is it's hard to identify patterns because it's happening like in back offices of, right, over 30 cities in the US. So it's hard, attorneys see what they see. They don't see what's happening elsewhere. And so being able to connect them, because they were actually running a hotline out of Miami for a while where they were trying to refer people who called their hotline to not even someone to represent them, but just to prep them. Because, right, if you have your credible fear interview in 3 days, right, it's really hard to be represented, but with limited forms of prep, right, at least people can be told what qualifies for asylum, what parts of their stories to stress. Sometimes they're able to get a continuance. For example, there's a lot of issues with bringing children into the interview, which has been really problematic. But again, without any sort of legal assistance, I've seen some of these redacted transcripts, like people are failing them because they don't understand what they're supposed to stress. And a lot of the officers conducting interviews are also not familiar with these kinds of cases. You can go to the next one. Okay. Again, these are places in the process where immigrants are less likely to have any form of support at all. And, if you think about many of us who do expert testimony, witnesses, those are generally for people who already have an attorney. There's some space in where sometimes with this prep work, attorneys, if they're not fully representing, could even enter a quick country conditions report. So there might be some avenues to help there. But, in these cases, like, people are much less likely to have counsel. And in fact, we see that now as a trend nationwide, where most of these cases in immigration court, the rate of representation has really gone down. But again, I point out that the rates of representation are much higher for decided cases, which I think makes a case for also us being able to pay attention to these earlier parts where people are largely, being attritioned, right, by the system, versus those who are able to get right all the way to the final merits hearing are much more likely to have had some kind of right support already within the process. And again, under these new expedited processes, and this is why we should watch out and fight against these, are fundamentally obstructing the right to meaningful access to counsel by design, right? It's just not possible. So the dedicated docket, and it's really hard to actually parse the data on this. We're working on this too, tracks, it's very difficult, but that representation rate is only about 15.5%, so much lower. And they found that minuscule portions were given asylum, and all of those cases were represented. And FIRM is even harder to find representation rates because it's by USCIS, and it took a congressional representative to get this data, and haven't gotten updates, but they said that representation rate was just above 2%, right? So very low. You can go to the next one. Again, these are just some of the problems we've seen in immigration court, and all of these get aggravated when you don't have access to counsel at all, and when you're on an expedited process, or when you just have overworked, right, courts and rapid kind of hiring of new USCIS officers and judges who are not always trained in these kinds of cases. For example, we see a lot of instances where the NTAs are not actually filed with the court, so they might issue these notices to appear to immigrants at the border, but they're not actually filed with the court. And in fact, that means someone's not in immigration proceedings. And this creates a whole lot of mess, because then you'd have to file with the USCIS, not miss the 1-year filing deadline. And sometimes they'll only give these notices, they'll file half the family, not the other half of the family, right? So we see all of these errors where attorneys say like their packets are all over the place, and USCIS and the court often have different requirements, and it's a mess. Short staffing, resources, like sometimes we've been asked to help, and this is a room that in some respects, advocates are helping, or law students are helping, things like helping people change their address at court. More training, people can also be involved in change of venue requests, which are huge reasons sometimes why people are being removed in absentia because they're not sure where to change their address. Like, people don't understand that ICE, right after they file that notice to appear with the court, when people go check in with ICE and they have an address change, they assume that ICE notifies the court, but they don't. And so people also have to change their address with the court, right? And these are just kind of things that even in your general kind of advocacy, you could talk to people about, which are really important. Like, I mean, we even found, and these are people who made it to their court dates, that when judges verified addresses, they were wrong 35% of the time, right? People are very transient in these processes. A lot of tech malfunctioning, issues with interpretation, which, I can answer questions about. Really problematic removals in absentia without actually complying, that people are receiving those notices, as I mentioned, are a mess. And then again, it's not necessarily always that judges are committing overt violations or not notifying people of their rights. It's often the kind of ways that they're doing that and the kind of advice they give around that, even when they're not really supposed to, that can sometimes deter people from actually accessing the limited rights that they have. You can go to the next one and let me know if I'm running out of time. These are some additional concerns that we found, especially like if you're put on this expedited 300-day dedicated docket, you generally don't know until you show up for your first master calendar hearing. And in fact, they used to post notices outside the court so you could see what dockets people were assigned to that day so you could go observe them. And now there's very little information. And so for the most part, from what we understand, people don't know they're on this rapid clock until they show up for their first court hearing. There's no other way for them to know that, which obviously then rushes them, right, immediately, right, without knowing that they had that, for example, when they crossed the border or received their notices. Just general lack of access to information. Issues with helping with asylum applications. This is just a picture of like the annotation that I made on one of them. I think there's a lot of role for whether it's scholars or advocates to volunteer at asylum clinics. It doesn't even mean helping with the more complicated parts of the claim, although there's ways that you can get trained to do that and help make sure people are actually stressing the parts of their cases that qualify for asylum versus the ways that they often tell their stories and helping them identify where the claim is. But sometimes really small details that people really need help with and that you kind of have to help them with, like even questions like when was the last date you left your country, right? Is actually really complicated for a lot of Venezuelans now who've gone back and forth to Colombia, right? Or to Peru or to Ecuador, filing an application for each member of the family, making sure you're checking off withholding and CAT as well, so people are eligible for that. Family compositions are really complicated as well, right? Especially in cases where one parent isn't a biological parent, right? These are all things that people often need help with through the process. That we have to keep in mind, but ways that asylum applications are almost impossible for people to fill out themselves, especially because they have to be filled out in complete and accurate in English. I mean, they even ask what year you went to elementary school, and I can't even remember when I went to elementary school, right? And so helping people through that process is really important. And again, these new policies which push ever higher bars on people. You can go to the next one. I think that may be the last one. So yeah, how we can use our expertise to help people through these parts of the process as well. Observe and document in court. Again, these are really good opportunities both to, I think, hold the immigration system accountable. They're also really good ways for those of us who teach to inform our students what the immigration system actually looks like so they can push back some of the dominant discourse of people not quote unquote following rules, right? Really seeing the ways that these are set up to fail people, how difficult it is to even understand, right, what's going on in court, even as a native English speaker. We can assist with change of address forms, so with additional training, sometimes with change of venue forms. Some, although these requirements are higher, although we spoke to some people who've done this and they have to be with, authorized organizations, but there's ways for non-attorneys to also be accredited representatives, right, and help people with prep, right, whether that's preparing paperwork or in some cases even appearing in court, knowing that most people are never going to find access to an attorney who's going to take their case. And again, this access to even just prep work, well, not even representation, is really helpful when there's not enough access to representation, especially on really short timelines. And like I just kind of put up this quote from Track here of why this is so important, where they say, right, it's well established that few unrepresented asylum seekers can even complete or file their applications by themselves. So they even have the opportunity to have a hearing on their claims, where most of us are assisting right in those final processes versus also really needing to help people so they can even have a chance, right, of getting that far in the process. Sorry if I want to answer questions.
Thank you, Rebecca. Are there any more questions in the chat? It looks like you answered Andrew's question about firm.
I can try to find the article and put it in too. They have a great report. So
we have time for 5 or 10 minutes of discussion and questions. Tom, do you have anything you want to add?
Rebecca, you and I have never met before, but I was just hanging on every word of your your presentation. And I thought there's just a couple for people in the group that are either not familiar with the context of the courts, or they're just beginning to tip their toes in the water. And just so to take some of what Rebecca was saying and kind of bump it up at a, a little higher level. I remember a few years ago, I had testified in this particular judge's court by phone and in person probably 20 times. And he and I had a bit of a relationship. So after my testimony concluded, we snuck out. Neither one of us wanted to be seen, but we snuck out and had lunch. And he was talking about the fact that a lot of these cases that he hears really are essentially death penalty cases. People who have experienced extremes of violence and will predictably experience extremes of violence if they're removed. There's not even a question about it. And I said, what does it feel like to be doing these cases? And he slapped his hand on the table at the restaurant. He said, Tom, if I was a criminal court judge trying a capital case, I would have an unlimited budget, unlimited time, a jury, experts on both sides of the matter to help me make sense of it. But I'm making these life and death decisions, usually in less than 3 hours. Rarely do the asylum seekers have counsel. Even less rare do they have an expert to help me make sense of anything. And, he ended up retiring early because he just couldn't handle the psychological, emotional strains of being in this kind of position. The former past president of the American Association of Immigration Judges has said publicly in numerous settings that these are death penalty cases being heard in traffic court.
That's exactly what I was just going to say. I hear that. And sometimes they don't even have a working printer. They're like, sorry, I'd give you an asylum application, but my printer doesn't work. Like, just the most mundane things of like these life and death implications is just, it's to watch.
Right. And then you also run into, and Rebecca, you were touching on some of this as well, you run into rules of evidence where there's variation between the criminal courts, civil courts, and asylum courts. For those who, at a very basic level, are new to this, immigration is a civil matter. It's not criminal. So that many of the protections that are baked into the Constitution and law to protect the rights of people in criminal and civil courts simply don't apply here, such as representation if you can't afford it. So like the rules of evidence from one judge to the next can be very different. I did a case a while back where in their closing argument, this was a Salvadoran a Salvadoran case. In their closing argument, the government asked for permission to walk up to the bench and present a document alleging that the respondent was a gang member. They had never provided any documentation of this, never said a word about it. The respondent's attorney didn't know about it. And so, of course, the respondent's attorney objected, saying, Your Honor, I need time to review this. This is critical because that allegation of gang membership nullified the man's entire claim. And the judge said, denied. He went ahead and made his ruling. Now, that would never happen in a criminal court or a civil court. So if you enter into this milieu, it's from one judge to the next one, circuit to the next one, city to the next. It is a very, very different and oftentimes unpredictable situation.
We have a question on the Trump administration's plans on the asylum question from Sonia Wolf. And Sonia, that is going to get a lot of attention next week. So I'd rather, if you wouldn't mind, defer that answering a question on the incoming Trump administration to next week, when we will have ample opportunity to look at the changes in the future. Right now, the introductory session today has been designed to introduce people possibly with no knowledge or limited knowledge or even some knowledge to the overall picture. And Rebecca has given us a great overview of the early stage process. And I just have to say, all of the estimates on asylum approval rates don't even count the fact that if you don't get the initial written application in, you're not even counted in the denominator. So already, we have a disparity where, depending on who's calculating it, If you have an attorney, you have something like, depending on the circuit in the United States, a 10% to a 75 or 85% chance of winning. If you were to include the master calendar hearings, then the approval rates drop by 70% in these categories. And master calendar almost never has an attorney president. I should note that legal clinics sometimes go to those hearings to look for the most eligible candidate for political persecution or likelihood of torture in order to try to recruit attorneys on their behalf. And then presumably the attorney can get in to discuss with the potential client. But if we're not even including the people who never have a master calendar hearing, one can only speculate at this point the number of people who basically are not going to have a chance to stop the removal process. Any other comments or questions from Tom or anyone in the audience? I do want to spend a few minutes just talking about the plans for the agenda for next week. I hope everybody who's listened have learned something, and I want to thank, of course, everyone who's been here today: Bobby Wu, Lisa Knauer, Tom Borman, and Rebecca Galemba for their contributions. This will be on YouTube in about a week with the ISA, and next week's speakers have the option to opt out of the recording process. I will also say that we have some absolutely terrific people lined up next week on November 21st from 2 to 5 p.m. So it'll be an hour longer, 50% longer than what we had today. We're going to talk about the sponsoring role of NGO clinics or legal clinics, somewhat analogous to what Bobby Wu provided us from the viewpoint of a corporate law firm doing pro bono work. And we'll have a discussion from immigration attorneys who make a living just from immigration cases. I'm really referring to the asylum practice, not finding visas for corporate executives who generally don't like the term migrant or immigrant and like to refer to themselves as expats, which is kind of a class-based orientation to that distinction. I will have a discussion on hard cases, such as, what about social group persecution, which is the fifth of the 5 categories, which historically has much, much lower approval rates, but lots of inroads made there. What happens when your respondent is not considered to be credible by the judge, or, is it worth continuing at the case? Because that's basically a denial verdict in waiting. Limited documentation, no legal representation, past voluntary removal, which means you forfeit your right to apply for at least a period of time if you take voluntary removal. Aggregated felony problems that remove you from consideration for asylum. Multiple country entries. Should you be talking about country conditions in every country the applicant or respondent, as we've been calling applicants, the country conditions in all those countries? Because technically, according to the law, you can be removed to any of those countries and not your original country. Failed credible fear hearings, which we've talked about a little bit today under Rebecca's discussion. And so the differences between Convention Against Torture, legal basis, does that have any implications for you as an expert as opposed to an asylum claim? Mark Unger is going to speak about police persecution from police violence from Brooklyn College. Tom will be back discussing how you interact with attorneys, Tom Borman. Hopefully Rob Smith will be with us to talk about interaction with applicants one-on-one. Lisa Knauer will be speaking on ethical issues, specifically about pro bono situations versus offers from corporate law firms, or maybe even immigration attorneys, how much to charge, and whether, is it fair for immigrants to pay anything, although some do have family and some are working and have enough money. If you're worried about getting paid for your time, Sarah Burst Bishop will be speaking, and from Baruch College CUNY, perhaps on misinformation and distortion of statistics. And I'll be talking about qualification challenges to your ability to testify in a defensive proceeding in immigration court. And then, of course, we'll have the discussion of what all of this means with the intended changes by the Trump administration that's coming in, both those they've already announced publicly, those that may be likely that they're in that 2025 report that Trump says he's never read and has nothing to do with, but many of those people have already been hired or announced that will get positions, staff positions that don't require Senate confirmation, for example. And we'll have at least a half an hour of general discussion and question and answers from the audience next week. So a 3-hour session. The registration link is different from the one today. So if you're in the audience and you want to appear, you click on in a similar way on a different link from ISA so that you're admitted into the audience. And then the presenters will also have a presenter's link for that session next week.
Am I allowed to answer Sonia briefly on one of her questions?
Of course.
Thanks. No, I just thought it was a really good question, because I think securing the border, right, the new rule that went into effect, like that is something we likely will see continue along with probably a host of other things. But I do think there are things maybe that could be done on the Mexican side, and it's really hard to get around, but it's not impossible. Again, what attorneys have told me in terms of the kind of prep work, like the one exception besides using CBP-1 are victims of human trafficking in exceptionally compelling circumstances. And while that sounds really high, in fact, when people are prepped, they often have those conceptually compelling circumstances. So preparing people, like if they're victims of very violent crimes in Mexico, which many migrants are, right, human trafficking or medical conditions en route, they can often actually get around those bars. Also informing people in Mexico about their right to request a credible fear interview, time to find an attorney, numbers of hotlines. And then the other thing, and I think people are not sure how this is going to work out, but many who do expert witnessing may see this later down the line, is that it's been so unclear and like poor of how this has been rolled out, is that it also applies to people who came in during the timeline who entered without inspection and who may then apply affirmatively for asylum later in the process and go through this might also be subject to these standards. And so if we see those cases later on in the process, being able to find ways to still make people eligible for asylum, taking that into effect, I think will be important.
Thank you, Rebecca, for that response to the question. And thanks, Tom, for sticking with us all the way through. And thank you to Hannah Lee and Joel for giving us so much help. And to the audience, thank you for your attendance and your questions. And I will ask Hannah and Joel to end the session now, but invite everyone to come back in a week's time, either live or in the future looking on YouTube. Goodbye.